Ready, start. The High Court therefore erred in refusing to quash the proceedings qua the appellants. As regards the registration of offence punishable under sections 377 and 506 of the Penal Code are concerned, it was submitted that no allegations whatsoever in that regard had been made against the appellants. This was clear from a complete reading of the FIR. Notwithstanding this position, the High Court erred in not quashing the proceedings even as regards sections 377 and 506 of the Penal Code. It was thus submitted that continuation of the criminal proceedings against the appellants would amount to an abuse of the process of law, and therefore the same ought to be quashed in so far as the appellants were concerned. Per contra, learned advocate appearing for the state of Maharashtra and learned advocate appearing for the complainant supported the impugned order. It was submitted that at this stage the court ought to consider the complaint in its entirety. On the perusal of the entire complaint, it was clear that an offence under section 498-A had been clearly made out against the appellants. The complainant had clearly stated that there was a consistent demand by the appellants for gifts and other items towards dowry from the complainant and her family. The items demanded had been mentioned in the complaint, and other better particulars could be brought on record as evidence. Thus, taking an overall view of the matter and on perusing the complaint in its entirety, the High Court was justified in refusing to quash the proceedings in exercise of jurisdiction under section 482 of the Code. It would be open for the appellants to defend the proceedings during the trial and seek acquittal therein. It was thus submitted that no case for interference by this court had been made out. Having perused FIR dated 6/2/2022 as well as the final report, we are of the considered opinion that the criminal proceedings initiated against the appellants pursuant to the registration of offence punishable under sections 498-A, 377 and 506 read with section 34 of the Penal Code deserve to be quashed. Before examining the FIR along with the complaint of the complainant, we may refer to the parameters that are to be borne in mind while entertaining the prayer for quashing of the FIR. If the allegations made in the FIR or the complaint, even when taken at their face value and accepted in their entirety, do not prima facie constitute any offence or make out any case against the accused, quashing of the proceedings would be justified. Vague and general allegations cannot lead to forming of a prima facie case. As regards the ingredients for making out an offence punishable under section 498-A of the Penal Code is concerned, the requirement is that there has to be cruelty inflicted against the victim which either drives her to commit suicide or cause grave injury to herself or lead to such conduct that would cause grave injury or danger to life, limb, or health.